Good morning, Your Honor. I'm Susan Lerner on behalf of Stone Properties Inc. The briefs that have been submitted in this case have set out the facts in detail, and the facts are uncontroverted. It is our position that these uncontroverted facts did not give the judge any basis whatsoever to find fraud in the transaction. The judge's findings were premised on a very legally insufficient conclusion, and that is that
if your client transferred assets at 1/10 of their value in order to avoid the debt that they owed to the client, I don't understand your position. To make a long story short, these were phony transfers.
Respectfully, Your Honor, they were not phony transfers at all, and that's where the fundamental flaw is.
There's no evidence that these transfers were made for a small percentage of their value?
Absolutely. The transfers were made beginning in 2005, before there was any dispute between Chickenhawk and Stone. This was a family business.
The question was, I asked you the question. There is no evidence that the transfers were made at a small percentage of their actual value to a person or entity who was virtually the same as the debtor.
If I understand your question correctly, the answer is yes, there was no evidence. The evidence was that monies were paid for construction to contractors, and Stone Inc., the debtor, received substantial equivalent value in return.
Well, the issue is equivalent. There was no evidence to the contrary.
Correct. If I understand what you're saying.
Well, I guess as I read the case, my understanding was that what may have been conferred to Stone, the property owner, was the value of the actual building that was constructed, because the money that was spent by the debtor were spent for construction work of the building. But there was no duty on the part of the debtor to build the building in connection with its lease, correct?
There was no lease. The lease didn't say you must construct, but there was nothing, and the evidence is undisputed, that this is no question. These are two family-owned corporations, and it's not unusual to have a separate corporation own the land, and that is done in business.
And it's also not unusual to build or expand the building in connection with a lease. Usually that provision is within a lease, isn't that correct?
Well, in typical, when you're talking about banks, and that's what the expert was saying, that if you had in a big corporation with even subsidiaries, you might have that. But there was nothing about this that was in terms of saying, well, oh gosh, light bulb goes off, this guy's making a claim, we're not going to pay him, we're going to build this building. That is not what
apparently the light bulb went off in the trial judge's mind after 4 days of testimony.
The trial judge, and we again respectfully believe that he was under a fundamental misunderstanding, and that was, it was one thing. Why would a long-term lessee pay to have a showroom built on a piece of property?
Except to shield that building from its own creditors. It makes a lot of sense to me.
Well, respectfully, the record does not support that.
If they kept it in their own name, in the creditors, in the debtor's name, of course, that's right. But they didn't. They gave it to somebody else who was not subject to execution on their own debt.
Again, it's important to back up, and I think that the Gass versus Conroe case from this court, and Judge Schwartz was on that panel, it is about as close
I
as
remember
you get.
perfectly.
Well, it was a long time ago, so.
Well, I still remember it
1995.
perfectly.
Well, then you know, in that case, similar situation where you had Mr. Glass who sells a commercial building, he deposits the proceeds, like, at the time, obviously, the realtor thinks he's owed a commission, money goes into their joint account, and it is spent in the course of over 1.5 years before Conrail files suit. Same here, you have payments beginning on this.
Now you are now saying that this was not in contemplation of the, or let alone in avoidance of the debt.
Absolutely not, and that's the thing I think that the judge was misguided in that the uncontroverted evidence is that this family started their business in 1992.
It was just coincidental, huh?
Well, you can, I mean, and you could say that, but it's not even so much, I mean, like, oh, this is an after the fact.
Yeah.
What it really is that these folks got a judgment, and they went back and created a fraudulent transfer claim that is not supported in the facts or in the law. And
Factually, the lawsuit brought by FS Inc. was brought to, on the contract, was brought in 2006.
correct.
There were transfers, I don't know how much, but there were transfers after that, were there not?
There were transfers before and after. Before the lawsuit was filed, in fact, before the dispute.
Do we know how long before the lawsuit was filed that the dispute itself arose between the two, FS Inc. and
Chickenhawk?
Chickenhawk?
The record is silent as to when the exact date that the lawsuit, that Fortune Stone Inc. filed the lawsuit, but it was in 2006. The dispute arose.
And you say there is no evidence that these transfers were made in order to avoid the pending or impending obligation that they owed to your opponent.
Yes, Your Honor. What you have.
There's no evidence of that.
Correct. What you
because that's the only way you can win. There is no evidence of that.
Correct. There's no confident evidence. There's this argument that they now are making that.
Well, there's no question about the transfers, about who paid what at what time for what. There's no question about that. There's no question that the other party was in bed. Not anything wrong with it. That they were the same people as the corporation. Isn't that what the transfer to avoid creditors, to avoid a creditor in the fraud of creditors is made to prevent?
It's not made to prevent what happened here.
Okay.
And the reason, it very simply, is that you had an ongoing business that was making transfers, expenditures, a full year before the Chickenhawk dispute began, which was in April 2006.
That's when the lawsuit. What is the earliest record? What is the earliest record evidence of dispute between FS Inc. and Chickenhawk? What is the earliest one?
The earliest is April 2006.
When the lawsuit was filed. There's nothing.
That was the one that disputed the claim, right?
That's when they filed the lawsuit.
No, Your Honor, I'm sorry. The earliest, this is, I mean, it's not even the earliest, it's the undisputed evidence is that there was a falling out, there was a meeting in April 2006. There's a dispute as to what happened at that meeting, and then the law then...
The April 2006 meeting was about the dispute regarding the commissions, correct?
Correct.
And that's when Chickenhawk or its principal felt that it was not being paid the commissions and that they were in arrears, correct?
That's his testimony.
That's the evidence.
Yes.
And then the lawsuit was filed in June. The lawsuit was filed in June of 2006 by FS Inc.
Your Honor, the lawsuit was filed sometime in 2006.
And when was the counter claim filed?
The counterclaim was not filed until March 2007,
And that's when Chickenhawk alleged that it was owed the commissions, that mediation had broken down, and that it was part of the case of commission.
Yes, Your Honor. So what you have is you have an ongoing plan to take these folks out of their temporary office, which was a trailer, and in 2005, we're going to build this,
Werner, that's way beyond this. There's no question that they were right, that not your present client, but their debtor, the people that they were dealing with, had withheld the money, and they owed the money.
well, at the
The
time,
only question is whether they concealed their assets by transferring it to a sister, or brother, or sibling corporation.
and they did not, because what they were doing was perfectly reasonable for them to be doing, spending these monies, and
That's a question of fact.
well, it is not in that it is, the judge's decision was based on, you don't build you don't build a building on land you don't own. That was,
Counsel, you have reached your time limit.
Thank you for giving me extra time. I'd like 3 minutes on this.
How about, 'cause
2 minutes?
I just, 1
Thank
minute,
you.
1 minute.
May it please the court, my name is Greg Olson, Morgan Olson and Olson LLP, and with me is my partner Brian Gottlieb. We represent.
When did this dispute begin, and what was the status of the building at that moment?
The dispute.
On the record. Just
What the record
out of the
says.
record. What does the record show?
The record shows that in late April of 2006, Mr. Shook, on behalf of Chickenhawk, went to Mr. Bernal's office and said, "You're already behind $30,000. We've got a whole bunch of payments coming down the pike. I want to make sure I'm going to be paid on time." In April of 2006 at that meeting, Mr. Bernal said, "Well, Craig, we're going to have to start lowering your commissions on sales that have already been made, over $11 million worth, by the way."
And was the building under construction at that time?
It was not. And what the first transfer.
What is the record evidence? Where's that in the record?
PX 25, Plaintiff's Exhibit 25, shows every one of the fraudulent transfers in relation to when the monies were due. And here, John, I want to tell you straight out the top.
And you're representing that they show that every transfer for the construction of that building occurred after April of 2006.
Yes, and I'll only qualify that to this extent. In I believe it was the reply brief, the appellant now says, well, we did some permitting back in 2005. We've got the bills for the permitting. They were in 2006. And I read the transcript. In a way, it was quoted. They said when they had done these plans, when they did the warehouse that was paid for by the property owner, they also had what they called a showroom, and later it got turned into an office building. I don't know anything about payments for that. It didn't say in the transcript about permitting. It just said that those plans had been drawn when they did the warehouse plans that were built by the defendant, Stone Properties, in 2005. They had also shown a showroom. That's all. But what the record that we're traveling on is actually the permitting and so forth. In April 2006, the defendant was, Stone Inc. was behind by more than $30,000. By the time of then what happened right after that, there had to be a demand for mediation before we could sue. It just took a number of months for that to go by. By the time of the first transfer that we sued upon was July. It was only $60 for, I think, Miami-Dade. By then, the past due commissions had gotten up to about $86,000 or $87,000.
The lawsuit was filed in June or July?
The demand for mediation, I believe, was made in July. The threat to sue, which is one of the badges of fraud, was made at that April meeting. And that's where Mr. Shook says, you're not going to lower my commissions with my agreement. If you don't pay me what you owe me, I'll sue. And that's when Mr. Bernal came in.
The only thing that has been paid for in April 2006 is the permit.
Not the permit, Your Honor, but the plans that were drawn for the warehouse also happen to include a showroom for down the road. That's all that's in the record. Plans earlier.
Was it shown for what corporation those plans were were contemplated.
I know that I never really got a chance to look at the plans too well. There were these giant plans that were introduced, but I do believe it did say Fortune Stone Inc. on one of them. Yes. But here's the thing, Your Honor, as far as the evidence you asked earlier, in my humble opinion, the evidence is overwhelming on actual fraud for the trial judge decision to be affirmed. The evidence is overwhelming that there was no reasonably equivalent value and that they knew or should have known that they weren't going to be able to pay these debts to the Wachovia Bank and to my client. And so appellant tries to argue that these facts are all uncontroverted, and all I've seen throughout their briefs is challenging all these critical factual findings of the trial judge. One thing I wanted to point out, just a couple of things from the reply brief, the argument that this is not an insider transaction. For starters, in the definition of insider, it's the one definition under the Act that says insider includes all these things. Everything else is insider means this, means that. It was intended to be inclusive. I cited cases that said when you have a very close relationship, that is a badge of fraud. I cited another case that showed that LLCs are treated the same way just because they're not mentioned. So there's no question that it was an insider transaction. And it was a little surprising to me that...
So what was the transaction?
The transaction was that what happened was the debtor, after in April of 2006...
was the transaction the spending money for the construction, or was the transaction giving Fortune Stone Properties building that they didn't pay for?
The transaction was the movement of money. And that all of these, the transfers, in other words, was the movement of money. What Fortune Stone Inc. could have done was simply written checks to its sister corporation, and the sister corporation could have then paid the bills and avoided construction liens going against the property.
Why did it have to do that? Why couldn't it just pay the contractors directly if it was going to be using that building?
Well, it did pay the contractors directly, right. Judge Fernandez, but the point of it is this. There was absolutely no reasonably equivalent value given to the debtor in exchange for this. And as I cited to you the comment to the
construction of the building wasn't reasonably equivalent value?
But they were building the building for their sister corporation, which is the point of the Fraudulent Transfer Act.
Well, they alleged that they were building the building on the sister corporation's property for their own use.
They were going to use it.
They didn't own the building.
But they were also paying rent for the use of the property. This is the frustrating thing. The lease said pay rent. Well, all along they paid more than they should have because, yes, my famous argument, right hand to left hand that I said over and over because that's exactly what was going on. They paid more rent. When it came, there was nothing in exchange for these payments. Some year later, they started to use the building, at which time they went from $12,000 a month in rent in May of 2007 to $30,000 in June of 2007, and then $15,000 a month thereafter, which is an increase of 25%. The lease said nothing about building a building. If this wasn't an insider deal, it would have never happened.
So they were paying more rent because now there was an improvement that they were using, meaning the building, and therefore the ability to rent the space was more valuable to Fortune Stone Inc., even though Fortune Stone Inc. was the one that paid the money to build the building.
If I was less of a cynic, I would agree with you. It didn't make any difference to Mr. Bernal. He was both sides of the equation. He needed money over here, he moved it. But what happened in April, and he said, I'm never going to pay you over that.
Was the judgment debtor, and the right hand was not. And then when they took it from the left hand to the right hand, they avoided execution on the debt.
And that's the exact purpose of the act, is to stop that from happening.
Tell me something. Why does your client have the right to foreclose on the property? Meaning, and I'm not really a foreclosure proceeding, just a sale. Why does the judge have the right to sell the property to satisfy this judgment?
Because under the act, there are broad equitable remedies available. I did lay this out in the answer brief, but it allows this to happen. And I gave you two examples of cases where when there's a complete nexus, and this matter was already before this court on the whole issue of whether we properly had a lis pendens. It was before the court earlier, and this court determined we did. There was a nexus where you could trace these payments that became incorporated into the building. And so based on that,
so the sale would be subordinate to any superior liens or mortgages or anything of that nature?
Yes, sir. And that's why there was no one else to foreclose out except our defendant, Fortune Stone Properties. We're subject to 2 prior mortgages. My client will never come close to being made whole in this deal. Fortunately, we were able to find nearly $500,000 after Mr. Goodall said he'd never pay another dime.
That is not relevant to us. Thank you.
Okay, thank you.
Permitting for the office building began in 2005 as paid for by Fortune Stone, transfer 3, page 369. The plans submitted to the county were cashed, and council said, well, I didn't really pay attention to what the plan said. Quote, new office facility, Fortune Stone Inc., site plan, existing phase 2. This was phase 2 of a long-term project that was going to be paid for by the tenant. Council said, they were building the building for the use of their sister company, the holding company that owns the land. That's simply not what the record reflects, not one iota.
Did Fortune Stone Inc. occupy the building eventually?
As a matter of fact, they did, Your Honor, and they used it for almost 2 years until 2009, until the biggest recession since the Depression hit, and they could no longer stay in business. If that hadn't happened, they would still be there using the building and defending that Palm Beach County lawsuit
and paying their debt.
Your Honor, that was a disputed claim that did not materialize as a judgment until 2 years after the transfer.
We all know you don't have to have a judgment in order to set aside a transfer in defrauded creditors.
But there's not one iota of fraud.
The one iota argument.
And we submit this matter should be reversed for entry of judgment in favor of. Thank you for your time and attention.
The next